Cordial greetings. I am Camilo Escobar, JURIDAI founder, JURIDAI founder, Juridical Plus AI founder, that is JURIDAI founder. And today I'm going to explain the principle of confidentiality regarding artificial intelligence, regarding AI. Because at JURIDAI, we explain the general principles of law regarding AI to show how AI exists in a good way, how it can be something good, something that makes well-being, something for the well-being, something for good. So about confidentiality, it's important to recognize or properly to have in mind that, to keep in mind that the way to manage information, any kind of information, is defined by the law as a whole, by the whole of what is defined in the law, by the whole of what is defined in the whole of law. So the way to know how rights and duties exist regarding information is through the knowledge, is by knowing the law, what is defined in the law as a whole, in the whole of law. So is through the knowledge of how rights and duties exist. And rights and duties exist based on what is defined in the general principles of law, on the so-called general principles of law, on the principles of law, on the legal principles. Because each legal principle, each principle of law, each law principle defines part of the way of existence of rights and duties, and properly the whole of what is defined in the whole of the general principles of law defines the whole of the way in which rights and duties exist. So the general principles of law define how rights and duties exist. So regarding confidentiality and in general regarding the information management, the management of information, what is relevant, what is determinant, what is necessary is to know and apply what is defined in the law, to know how to, for example, for instance, how to classify information, how to know the freedom and the limit regarding the usage of an information of a specific information, and in general to know how rights and duties exist regarding information. So with respect to artificial intelligence, what is relevant is to know how rights and duties apply, both regarding artificial intelligence as a whole and regarding the specific aspects, the specific facts, the specific facts related to information, related to the information that is related, that is linked with the specific artificial intelligence that is involved, that is existing, that exists inside a legal relationship, that is inside an environment related to what is defined in the law, inside the situation, the respective situation in which rights and duties apply. So to know how to manage, for example, the disclosure or non-disclosure of information is by knowing the whole of what is defined in the law and by applying that to properly get the exercise of rights and duties regarding it, regarding the information related to an artificial intelligence product, to tailor to the way, to the extent of the way, to the extent of each legal relationship, that is to the extent of each environment related to what is defined in the law. That includes an artificial intelligence, to the extent of each artificial intelligence tailored to the way in which the facts and properly the whole of fact of each legal relationship related to it, related to an artificial intelligence exists. So it's not about creating self-regulatory instruments that includes elements that are opposite than what is defined in the law, opposite to what is defined in the law. Because those self-regulation, self-regulatory, for instance, documents are invalid, are not legally valid, are not legally recognized, are not binding. So it's about, of course, self-regulating each legal relationship. That is, it's about the enjoyment of rights and fulfillment of duties of um, the way, or properly based on the way in which rights and duties exist, tailored to the facts and properly tailored to the whole of fact of each legal relationship, but that legal relationship, or properly that self-regulatory initiative, that self-regulation is only valid when it coincides with what is defined in the law. So for example, to self-regulate, the way to manage the information related to an artificial intelligence product is by knowing and applying the way in which rights and duties apply, exist, proceed, face to it regarding the artificial intelligence, the respective artificial intelligence. So it's about knowing and applying what is defined in the general principles of law to the extent of the facts of each legal relationship that includes an artificial intelligence product, that includes this kind of object, this kind of product. So to know the rights and duties, the freedom and limit with respect to information regarding artificial intelligence is by knowing the law as a whole, the whole of what is defined in the law, and by applying it. This is the only way to know how to manage information, how to use information, and properly how information exists in a valid way, in a legally valid way, in a good way, in a valid way, according to what is defined in the law. The only way to know how to manage, how to use validly information and properly how information exists in a legally valid way regarding artificial intelligence is by knowing and applying what is defined in the law, the whole of what is defined in the whole of law. This is the unique way to make a good AI, to make sure that there is a good AI regarding information, by making sure that there is the exercise of rights and duties faced to it, to the extent of the way in which the respective artificial intelligence exists, tailored to the way in which the respective legal relationship connect to it, link to it, exists. Thanks so much for your attention, and I invite you to www.juridai.co to know what we do, to know our legal education offer regarding artificial intelligence, and to know our blog. Thanks so much. Bye-bye. Take care.